Good morning to all of you. Thank you for being on time. That is always a good sign at the beginning of any presentation on any sessions that everyone is here on time. So as you may have already noticed, my name is Sandy Mojica, and the topic that we're going to be covering today is child labor laws. So the class itself, the session is going to take about an hour. We're going to go over some of the topics. We're going to divide the class in three sections, three parts really. And in those parts, I'm going to be going over the history of child labor laws. How do we define child labor laws? What are they really? What does it cover? How does it work? How does it apply to you? And how do you stay in compliance? Those are the main points that we're going to be covering today. So again, this presentation will take approximately an hour. I will test your comprehension before we change from part 1 to part 2, from part 2 to part 3, and then at the end of part 3, I'll give you a summary at the end of all the everything that we have gone through. And again, if at any point during the presentation itself, you don't have to wait for the question session. If you have a question, something that you didn't understand, please go right ahead and ask. Let me know if you have a question. I will call you and let's make the answer. So get a pen and paper ready, and we're going to start taking some notes. I want to start really by an activity to get to know you guys. So let's get ready for this. Okay, so like I was telling you, the first thing that we're going to do is a quick little game. Sort of a little game. So as we go around the room and you are saying your name, where you're from, what is it you do, all stuff about yourself, give us three things. One of them is going to be a lie, the other two are going to be real stuff. So we're going to try to figure it out. So when we come back around, when everyone finishes talking about themselves, we're going to try to identify the lie in every single of those things. So take your time, go right around the room, and let's see what happens. That was good. Everyone went around. So we were able to identify some of them we were not. So now it may sound like a silly game, but this game itself was presented to me, or came up to my attention in graduate school by one of my colleagues there. So the main idea of the game is really short. It was a game. What did it do? What it does is it first creates a bonding with your coworkers. You feel more at ease because everyone's talking about themselves. You start building the team. And at the same time, you get slightly better at identifying people that may not be telling the truth. Now, it's not always a bad thing, but you don't want people not telling you the truth, and you want to be better at identifying the lies. Now, it is your business. You do not want to waste money unnecessarily for things that you don't have to. So the main thing is, if you learn to identify the truth and the lies, between the lies, that's going to be a great thing for your business. So remember, the truth and a lie is a good team building exercise that you could take it back to your employer and do it there. So it was easy again, but in real life, it is very important to identify the truth. So let's go. And as we now move on forward, you're going to notice that it's going to be more of me talking and you listening. And again, if you have any questions at any point, let me know. But it's going to be most of me talking as we move on to part number 1 and the objectives. So here we go. So we're ready for the objectives. So by the end of this training, what I want you to have taken away from this is the history, the law, and the compliance. So part 1 is going to be everything about the history of child labor laws. Part number 2 is going to be the law. What are the requirements? What are the things that you need to follow to not have any problems? And part number 3 is compliance. And in the compliance section, not only am I going to tell you how to stay in compliance, what to do to stay in compliance, but I will provide you with examples of organizations that have gotten in trouble for not following the law. So from here on out, it's going to be me talking for a bit about the history. When we get to the end of the history part, we're going to have a quick 3-question test just to see how you guys are doing. So just pay attention, take notes, and again, ask me any questions if you have. So let's get ready for this. Part number 1 begins now. As we go into part 1, the history, I will provide a brief but inclusive history of how we got to where we are today and why it is so important to protect our children. In 1884, the Bureau of Labor Statistics, or BLS, was created, and 2 years later it published the first annual report. It was a study of the Industrial Depression. It was estimated that in 1900, 1.75 million children were employed. In the South, 25% of the labor force were children under the age of 15, and about half of them were under the age of 12. In 1913, President Taft signed into law the creation of the Organic Act, which creates the United States Department of Labor, or DOL. At this point, the Bureau of Labor Statistics is moved to the Department of Labor. In 1915, the first monthly report of the BLS is published. The report includes data on the economy, employment, inflation, productivity, occupation, injury and illness, and wages. In 1916, for the first time, workers become eligible by law to receive compensation due to injuries or illness contracted while at work. In addition, both in 1916 and 1918, the Supreme Court of the United States ruled that laws restricting and protecting child labor were unconstitutional. William N. Dunk, also known as the father of the 5-day workweek, establishes the workweek consisting of 5 days. Frances Perkins, also known as the Trailblazer, became the first woman to be appointed, the longest-serving Secretary of Labor, and the architect of the Social Security, the maximum hours to be worked, and the minimum wage. She also oversaw the creation of child labor laws and unemployment insurance. Unfair labor practices are defined in 1935, and workers have the protected right to have a collective bargaining agreement. New regulations in 1937 protect the health, safety, and welfare of workers. Contracts were also encouraged for apprentices. In 1938, the Fair Labor Standards Act, or FLSA, is created. The 40-hour workweek is born, overtime and minimum wage are specified, and child labor laws are standardized. The Wage and Hour Division is created to enforce the new standards. In an effort to end child labor abroad, in 1947, President Truman creates the Bureau of International Labor Affairs. 2 years later, in 1949, Congress amends child labor laws to add more protections. OSHA becomes law in 1970. It was created to ensure workers' rights to a safe and healthful place, and in 1999, the United Nations adopts and ratifies Convention 182, which defines a child as anyone under the age of 18. Child trafficking is brought to the forefront, and that same year, Alexis Herman, among many of his accomplishments, adopts the ILO's Convention 182. As you can see, child labor is very difficult to eradicate. Even after all the protections that have been put in place, abuses still occur on a regular basis. The International Labour Office, ILO, estimates that around 250 million children under the age of 14 work for a living. It is also estimated that almost half of those minors work full-time every day of the year. ILO has calculated that somewhere between 50 and 60 million of those 250 million children are between the ages of 4 and 11. If you think the United States is a leader in protecting minors, then the next statistic is going to surprise you. It is estimated that between 800,000 and 1.5 million children between the ages of 5 and 15 work on the agricultural industry. These children face a number of challenges, and their life expectancy is 49. As we have now concluded part 1, I want to ask you a few questions on test your comprehension of the subject before we move on to the next section. Question number 1. In what year was the FLSA established? And as a bonus question, what does FLSA stand for? The year is 1938, so that was good. And if you said that FLSA stands for Fair Labor Standards Act, that's even better. Question number 2. What was the person, or who was the person, rather, that oversaw the creation of child labor laws? If you said the Trailblazer, you get extra points. And if you said Frances Perkins, you got the right answer. Question number 3. In what year was the International Labour Organization adopted? That would have been in 1999, when we adopted Convention 182 for extra points. We're now ready to move on to part number 2, the law. So as we begin, the first thing is, what are child labor laws? The Department of Labor monitors and enforces a number of provisions that protect the opportunities of minors to an education and prohibits the participation in employment that is considered to be hazardous in nature. These provisions are found under the Fair Labor Standards Act, or FLSA. The state of Florida has added additional safeguards to these provisions, making them even more strict. As a result, Florida employers have to go by the stricter version of the law, whether that is the federal or the state. The state of Florida requires that employers who employ minors first obtain proof of identity and age, and keep it on file for as long as a minor is employed. As for the state of Florida, these requirements can be fulfilled by obtaining a photocopy of the child's birth certificate, a photocopy of the driver's license, a certificate issued by the school board where the student is attending certifying the identity and age, or a photocopy of the passport and visa that shows the age. In addition, minors have to have access to the poster where child labor laws and their rights are explained. Even though minors are not allowed to work in adult theaters, in order to fight human trafficking, adult theaters have to obtain and retain copies of employees' identification and verify their validity prior to their first day of work. These copies are to be kept as long as the person is being employed and up to 3 years after the employment has ended. In addition, the state of Florida has the right to, at any moment during business hours, enter in an establishment and go through the record of the employees. Under Florida law, anyone under 18 years of age is classified as a minor unless the individual is or has been married, is or has served in the armed forces of the United States, a court has ruled that work is in the best interest of the minor, or the individual has graduated high school or possesses a high school equivalent. Even when this is the case, minors, or anyone under the age of 18 for that matter, are still required to have and meet the minimum age to work at different establishments. For example, regardless of the exemptions or court approvals that they may have, anyone under the age of 18 cannot work in a place where alcohol is served or in an adult theater. In regards to age, there are technically 3 groups: minors between the ages of 16 and 17, minors between 14 and 15, and those under 14 years of age. As it is with most laws, there are further restrictions, limitations, and exemptions that can be made to accommodate minors and their needs. For example, minors under 14 years of age are technically not allowed to work, but with the proper exemptions, they could deliver newspaper as young as 10. In addition, if they work for their parents, they could do it at an even earlier age, so long as the environment is not hazardous in nature. Because the state of Florida has provisions that are stricter than the federal government, I will go over the Florida rules and specify when the federal law is the one being used. Florida does not allow minors between age 16 and 17 to work during school hours, unless they meet certain parameters. Minors in this age group cannot work before 6:30 a.m. or after 11 p.m. on a school day. If a school day is to follow, minors can work a maximum of 8 hours in one day and a total of 30 hours in 1 week. When school is out or the following day there is no school, the hour restriction doesn't really apply. As we can reference in the slide, minors between the ages of 16 and 17 can work from Monday to Thursday, anytime after school until 11 p.m. On Fridays, there is no 11 p.m. restriction because there is no school on Saturday. An additional benefit is for Saturday that they could go at any point because there is no school that day, and they don't have a maximum of 8 hours that they do on Sundays because on Monday there will be a school. So the least restricted day will be Saturday, and then Monday to Thursday will be the most restricted days. As we move on to the second group, minors between the ages of 14 and 15 are further restricted to a maximum of 15 hours per week. As the table shows, the window available for this group to work is very small during the week, making Friday, Saturday, and Sunday the ideal time to have these minors working at your establishment. This group has additional restrictions when school is not in session. Minors in this age group can work up to 40 hours when school is out, so long as this is on between 7 a.m. and 7 p.m., unlike their older classmates. In addition, the federal laws for these minors, 14 and 15, allows them to work up to 9 p.m. when school is out and there is no school the next day. As we take a look at the table, we can see that Monday, Tuesday, Wednesday, and Thursday are the most restricted days of the week. Minors can only work up to 3 hours per day and they have to be out by 7 p.m. On Fridays, Saturdays, and Sundays, they could work a maximum of 8 hours, with Friday and Saturdays having the ability to have them work until 9 p.m. By now you have noticed how cumbersome a schedule for minors can really be. To make it even more challenging, breaks have to be taken into consideration when scheduling minors. Not adhering to this simple step can open the door for violations and penalties from both the state and the federal government. Minors have to take an uninterrupted 30-minute break for every 4 hours they work. If the minor works for 8 hours, 2 30-minute breaks have to be taken. If you think that's simple enough, that is when the breaks become problematic. If a person works 1 minute more than the 4 hours, that creates a violation. If the minor takes 1 second less than they're supposed to for their breaks, that becomes another violation. And an additional break of 30 minutes may have to be taken in order to show the uninterrupted 30 minutes. Breaks are very important to take into consideration when completing the schedule, because unlike adults, the timing is not mandated, minors have to take a break or violations will begin to pile up. As you can see, the FLSA has 17 occupations that are banned for anyone under the age of 18. As you can see, many of them begin with the word power. Minors are not allowed to use power tools at their place of employment. I will go through each of the 17 occupations and provide a description based on the restrictions from the FLSA. As you're going to notice as well, the state of Florida has further restrictions and exceptions based on the type of employment and the age of the child. As before, power-driven machinery are not allowed for minors, with the exception of power mowers with blades 40 inches or less, or farm tractors. The minor still needs to have training prior to using this equipment, but as long as they're supervised, they're okay to use it. As it has previously been mentioned, there are 17 occupations that minors are not allowed to. Let's begin with hazardous occupation number 1, which is manufacturing or storing explosives. Regardless of marital status or court order, anyone under the age of 18 cannot work where explosives are manufactured or stored. As an example, minors are not allowed to participate in the making of fireworks, but are able to work in a retail location that sells ammunition, guns, or even at a police station. To further clarify the point, minors can work in these establishments so long as they are not responsible for handling or storing the explosives. We now continue with hazardous occupation number 2, which is driving a motor vehicle or work as an outside helper on a motor vehicle. The WHD restricts minors from driving on public roads as part of their jobs. Employees under the age of 18 are not allowed to be outside helpers, meaning that they ride outside of the cab for the purpose of transporting or delivering goods. In addition, employees who are at least 17 years of age can drive on public roads only if it is during daytime, a proper license from the state has been obtained, the vehicle doesn't weigh more than 3 tons or 6,000 pounds, seat belts are available, and the driving does not constitute a job requirement but is more of an incidental thing. In addition, the 17-year-old cannot spend more than 1/3 of the day driving, or 20% of the work week assigned to driving duties. The minor cannot tow vehicles, do routes or deliveries, transport more than 3 people, or travel more than 30 miles away from the place of employment. As we move on to HO3, which is coal mining, this hazardous occupation and most of the jobs related to coal mining are banned for minors. So do yourself a favor and do not allow anyone under the age of 18 to work for a mining organization. To reiterate, most of the positions that are associated with mining, especially coal mining, are going to be banned for minors. As we move on, HO4 is the occupation in forest firefighting, forest fire prevention, timber track, forestry services, and occupations in logging and sawmilling operations. So anyone under the age of 18 is restricted from occupations that involve putting out fires. It includes forest firefighting, the prevention of forest fires by conducting controlled burns, timber track, cutting trees, and processing them at sawmills. As a result, most of the occupations as sawmills are not allowed for minors. HO5 is in regards to power-driven woodworking machines. As it was the case with previous hazardous occupations, and as you will see later on with additional ones, minors are not allowed, they are banned from the use of power-driven machines at the workplace. This includes, but is not limited to, chainsaws, nailing machines, and sanders. It is very important that you keep minors away from this equipment, as violating this law could cause harm to the minors and could potentially cost you your business if they get injured. The next hazardous occupation, which is HO6, is the exposure to radioactive substances and ionizing radiation. Minors, due to the possible health concerns and a number of other reasons, are not allowed to be in close proximity or even worse exposed to radioactive substances. Because minors are still developing, the close proximity or worse exposure to radioactive substances could create malformations in their being. So be careful and make sure that they are not close to any of this material. HO7 continues on the theme that minors are not allowed to use power-driven machinery. In this case, HO7 is in regards to power-driven hoisting apparatuses. Minors are not allowed to work hoisting equipment that is power-driven. Examples of this equipment include, but are not limited to, forklifts, non-automatic elevators, backhoes, cherry pickers, boom trucks, cranes, and work assist platforms. So be aware of the equipment minors are using at your work site to avoid any violations of this law. Just like HO5 bans woodworking equipment, HO8 prohibits employers from allowing underage employees to work with metal forming, punching, and shredding machines. Tools can still be used, but power-driven machineries are not allowed to be operated by minors. So recapping, HO8 is regarding minors being banned from using power-driven, metal-forming, punching, and shredding machines. So keep minors away from these machines to allow any violation of this law, as this equipment is very dangerous and any violations could cost you thousands of dollars and even maybe your job. HO3 bans coal mining for minors, and HO9 does the same for all other types of minings. This ban is for most positions in regards to metal mines, quarries, underground mines, open cut mines, and sand gravel operations. As I mentioned before, avoid conflict and ensure that no one under the age of 18 is a minor. Occupation number 10 encompasses power-driven meat processing machines, slaughtering, and meat packing plants. HO number 10 bans, as the name says, the use of power-driven meat machines by minors. Some of the equipment not allowed for the use of minors are meat slicers, saws, and meat choppers. This ban extends to any location where this equipment is used, including restaurants and specialty meat shops. This ban also includes the prohibition of minors participating or undertaking the job of cleaning such machines or disassembling them. It also does not permit minors to use this equipment in other food items. Finally, as you may expect, minors are not allowed to work in many poultry, slaughtering, or rendering or packaging plants. Like on the previous occupations, minors are not allowed to use power-driven machineries, and in this case, it's inside bakeries. So HO11 covers power-driven bakery machines, and they include, but are not limited to, vertical dough, batter mixers, dough rollers, rounders, dividers, and cookie or cracker machines. HO11 does allow minors 16 years of age or older to use certain lightweight countertop equipment. Some of this equipment includes countertop mixers and pizza rollers. The 12th hazardous occupation is the operation of balers, compactors, and power-driven paper product machines. Minors are banned from operating all compactors, balers, and certain machines that are power-driven for paper products. Minors 16 and older can load but not operate or unload compactors and paper balers. The exception for these 16 and 17-year-olds are that they can upload balers and compactors as long as these machines have an on-off switch and either a numeric pad that requires a code in order to operate or a key, and neither the code nor the key can be accessible to the minors. When the machines are not being used, the equipment must have the switch on the off position. The equipment cannot be operational when it's being loaded, and the equipment must meet and continue to meet standards. A notice has to be on the machine disclosing the age requirements for using the machine. HO 13 encompasses the manufacturing of brick, tile, and any related products. Anyone under the age of 18 is not allowed to manufacture bricks, tiles, or any products related to them. It also bans minors from being part of any of the manufacturing process of these products. Hazardous occupation number 14 is the operation of power-driven circular saws, bandsaws, guillotines, chainsaws, reciprocating saws, wood chippers, and abrasive cutting discs. Regardless of the item being cut, the operation of wood chippers, cutting saws, guillotines, and bandsaws and circular saws are banned for minors. Minors are not allowed to help individuals that are using this equipment either. This equipment is extremely dangerous, and it's very important that you keep an eye on your employees and make sure that none of them, especially the minors, are not doing anything that could violate the law. The next hazardous occupation is HO 15, and it covers wrecking, demolition, and shipbreaking operations. Minors are banned from participating in wrecking, demolitions, and shipbreaking operations. Minors are allowed, though, to work in remodeling or repair jobs as long as their work is not extensive. Due to the nature of this occupation, you are better off not having any minors on site. Any miscalculation could cause an injury, and then a violation will ensue, as minors were not even supposed to be in any of these sites. So be careful and follow along. HO 16 covers roofing operations and work performed on or about a roof. Youth of 18 years of age or younger are not allowed to work on roofing occupations. The ban also includes work that is done for roofing purposes, either on the ground or above the roof. For example, working on a ladder, hoisting equipment, or using scaffoldings. There is a provision that allows 16 and 17-year-olds to do roof work if the employer and the school have entered into an apprenticeship. Make sure you have all your paperwork in order to avoid any possible violations. So we come to an end of the hazardous occupation. HO 17 covers trenching and excavation operation. HO 17 bans minors from working in trenching and excavation work. This restriction also applies to working in a trench that is deeper than 4 feet. Exceptions are possible with the RAD approved program. Make sure that you have the program up to date and in compliance, and that you have all the paperwork to back it up. Minors can work on farms with no real restrictions as long as they are working for their parents or guardians. If they were to work for someone other than their guardians, then the same restrictions previously mentioned apply to them. In other words, the age, times, conditions that were previously not a concern if they have been working for their parents becomes one when they work for someone else. In some cases, courts find that it's in the best interest of a child to work, and waivers are put in place in order to help the child be able to work. Child labor laws can be enforced at the federal, state, or local level, and everyone is responsible for the well-being of children, including civilians. Anyone that observes or suspects that child labor laws are being violated and does not report it becomes liable. State law allows the police and anyone working on their behalf to go into businesses during business hours and check the records. Under Florida law, any trial judge is able to issue warrants if they believe child labor laws have been violated or complaints have been brought up to their attention. They can also put together a grand jury to find more information and to make recommendations. Minors can be part of the entertainment industry with no real age restrictions. The non-hazardous requirements still apply, including avoiding detrimental effects to their morale, education, and health. In addition, employers have to notify the department when work with the minors begin, how many days they worked, the location, and the date of termination. Times for rehearsal, practices, and anything else that the minor did while employed counts as time worked. Employers in the entertainment industry wishing to work with minors need to apply for a permit and wait until it gets approved before they begin work. If a minor is found to have suffered or experienced dangerous situations while working, the permit itself may be revoked and the responsible individual or individuals may be charged with a misdemeanor. If it is found that this individual or perpetrator willfully inflicted the pain, then they can be found guilty of a second-degree felony misdemeanor. The state of Florida places education before any work experience and requires that employers do not impede the child's learning process in any way. Minors with the proper approval can participate in work experience during school time so long as it does not interfere with the education process. For example, minors between the ages of 16 and 18 can enroll in a youth vocational training program that is recognized by the state or the local school board. They can also have a reading agreement with an employer that allows them to get experience while still in high school. There are a number of laws that exist to protect minors from employers and their possible abuses, and when violations occur, penalties are assessed through the state and the federal government. Each day that a violation takes place, the incident is treated as a distinct offense, and each minor is treated as a different violation. In this case, the state of Florida goes by the federal standard that imposes a maximum fine of $11,000 per minor per violation. To put this into perspective, a minor will most likely not make $11,000 in 1 year, and in 1 day they could have multiple violations that could potentially add up to more than what they would have made in the entire year. It is critical, as you can see for your business and your bottom line, that you manage your minors with special care. Minors can be very helpful, but they can cost you your business if you do not follow the law. Some of the consequences for not following the laws are suspension or revocation of licenses and even jail time. Happy to say that we have finished the first 2 sections. We're about to go to part number 3. But before we do that, I just want to ask you a few questions like we did before to make sure that you have understood pretty much the material that we have covered, and that if you have any questions or any concerns, you could ask me now. So, question number 1. Does the state of Florida have the same rules as the FLSA? Now, we already know what the FLSA stands for. It's not Florida Support Assistance or anything like that, so we already know what it is. So, does the state of Florida have the same rules as the FLSA? So, the answer is going to be no. And in many cases, the state of Florida has stricter guidelines than those of the government. So, question number 2. How many occupations are banned for minors? Now, we spent a lot of time in this. There were a lot of information that I gave you about this. So do you remember what was the last number that we talked about? Of course, 17. There are 17 occupations that minors are not allowed to be associated with. Remember, there are a lot of restrictions, so don't break those rules. Remember those regulations. Question number 3. How often do minors have to go on break? Now, we spent some time on that as well. I would expect that by now you are quite familiar with the timings. Now, as you will see later on the next section, there are a lot of issues with people not following this specific rule. These are not guidelines. These are rules that you have to follow. And so, how often do you have to go on break? So it's going to be easy. Every 4 hours a minor is working, they have to go on a 30-minute uninterrupted break. Pretty much. And if they work for 8 hours, then they have to take 2 30-minute breaks. So just make sure every 4 hours that they work, they have to take uninterrupted 30-minute breaks. The only way you can help yourself to stay in compliance is to know and understand the requirements of the law. You have to train your teams so that they are educated as to what is expected of them, and you have to hold everyone accountable, including yourself. Minors need to know when they are supposed to go on break. Supervisors have to verify that minors go when they're supposed to, and managers have to trust but verify that everything is being done properly. In an effort to assist with scheduling minors, the state of Florida has mandated that when schedules are printed, if they include any minors, the names must be highlighted. This ensures that the supervisor as well as the team is aware of who the minors are in the shift. Staying compliant is critical, and training sessions are a very simple first step. Ensure that all supervisors at least once a year take some sort of training that will refresh their memory. In addition, remember to practice with any new employees and make sure that they too know the requirements. Verify their understanding by testing their knowledge from time to time, and by following these simple steps, you should be in good shape. These are only a few of the companies that were found to have violated the law when it comes to minors and breaks. They were all fined, and as a result, they received negative publicity that was potentially more damaging than the amount of the fines. For example, Hollister was found to have violated the break procedure on 127 different occasions in Orlando, and Steak and Shake, also near Orlando, was found to have violated the rights of all of the 6 minors that they employed. Finally, Panera Bread in Central Florida was found for not having minors take their breaks. In fiscal year 2010, the WHD conducted 309 investigations to determine the level of compliance with the youth employment provision of the FLSA. The 3 industries targeted were the fast food, full service, and the supermarket industries. The WHD randomly selected a total of 108 firms, 40 of which were selected from a database of employers with previous violations. The organizations were surveyed by investigators and the results were later analyzed for possible patterns of violations. The WHD reported violations they found to the state. The baseline for full-service restaurants, according to the WHD, was about 78%, meaning that 78% of the restaurants that made up the baseline were in compliance. It also found that 89% of the minors employed at these locations were in compliance. Unfortunately, 47% of minors between the ages of 14 and 15 were found to be working in violation of youth employment law based on the 2 pay periods that were selected. Some of the violations that were found were minors operating power-driven meat slicers and power-driven bakery machinery. Of the restaurants that were investigated, only 52% were found to be in compliance. Finally, the WHD found that 93% of the minors in the restaurants investigated were found to be in compliance. In this case, the overall findings suggest that many small establishments violated the law more often with less minors than bigger organizations with more minors. The baseline sample from the WHD found that 70% of fast food restaurants were in compliance with child labor laws. Overall, 90% of the minors were found to be employed in compliance. Unfortunately, minors between the ages of 14 and 15 were employed out of compliance at a higher rate than those of the baseline study. A total of 29% of the age group was found to be employed out of compliance. Of the locations that were investigated, 72% of them were found to be in compliance, and 97% of the youth employed was also compliant. The supermarket industry was found to have the highest level of compliance among the 3 industries. The WHD found that 82% of the baseline supermarkets were in compliance and that 98% of their minors were also employed in compliance of the law. Most of the violations found were involving paper balers and forklifts. Of the locations that were reinvestigated, 72% of the locations were found to be in compliance, with 95% of their employee minors in compliance. The survey also found some other violations. In this case, the Wage and Hour Division found that over half of the violations in each industry revolve around minors between the ages of 14 and 15 that would work more than the hours they were allowed to. Minors working past their standard hours made up 87% of the violations, with 55% of them working more than 2 hours past their standard time. Another 32% of them were found to have been working between 1 and 2 hours past their standard time. It was found that minors were hired as cashiers or cooks in violation of labor laws. Cashiers were found to have been cleaning or cooking, and cooks were found to have been working in open flame situations. The 3 industries were found, according to the WHD, to be in compliance with the minimum wage and the overtime laws. In summary, full-service restaurants were found to be the most repeat offenders when it came to being incompliant. Even though the number of minors employed in compliance of the law increased, the number of restaurants being repeat offenders was about half. The supermarket industry also reflected the highest level of compliance among the industries in the baseline, with 82% of the restaurants and 98% of its minors in compliance, but the reinvestigated locations showed a lower percentage on both numbers. Finally, the fast food industry was the only one that saw an increase on both numbers of restaurants in compliance based on the baseline and the number of minors employed in accordance with the law. I'm just going to give you some reminders of things that you want to avoid, because you don't really want to end up in trouble with the law. You really don't want to have any issues that you're going to be investigated or a family member is going to accuse you of having their child work more than they're supposed to or not taking their breaks. So I'm just going to give you some reminders, some frequent asked questions that we get as to things that may happen in the workforce, the workplace really, that may trigger people to believe that you may not be following the law. There are some pointers, some things that have happened, some findings that have occurred, and they're overall good best practices really that you could have in your business. So for example, according to the wage and hour division, we have been talking about them for a while. So they really are your best friend and your worst enemy if you're not following the law, my bad. So for example, according to them, about 160,000 minors are injured every single year in the United States. That's a lot of minors. Now you don't really want to have one of those minors in your payroll that gets injured because of something that you did. So just make sure that you're following all the rules to avoid any complications with them. So 160,000 of them get injured every year. Approximately 33% of them, of those that get injured, end up in an emergency room. Now, if one of your minors ends up in the emergency room and it ends up being that you were at fault for having them working on something that they were not supposed to, you're going to have to be paying those bills. And at this point, the health of the minor is the priority. But really, at the end of the day, it's your business, and you're going to end up paying for that if you were liable for those. Now, so we said that 33% of them ended up in the emergency rooms. 32 of those people that went to the emergency room ended up losing their lives in 2009. Now, so you definitely do not want to have any of those injuries or emergency room visits, and definitely not anyone losing their lives for something that they did at your employment. So make sure that everyone is following the rules and that you don't do anything that puts your business in danger. So remember, minors cannot cook in open flames. They just can't. So if you have anyone under 18, and let's say that you have a restaurant, you have open flames, just make sure that they're not in the kitchen, or at least that they're not around the fires. They better not be around there, just in case something does happen. Now, they could help outside of the fire, or they could even cook in locations where open flames are not around. So for those that have swimming pools, minors can be swimming coaches, can be instructors, can be lifeguards, as early as 14. But they have to have the proper certification and training on file showing that they are a certified lifeguard and that they have taken all the classes and they are up to date with everything on the certifications. So you could have lifeguard there, but if something happens and that person is not certified, then you become liable not only for having an underage minor serving the position of a lifeguard, but now if something did happen to the person that we're going to try to rescue, now you have something else in your plate. So make sure that if you are going to have someone serving as a lifeguard or in that duty, in that capacity, that person is properly certified. So another thing that happens quite often, no illegal deductions can be made from dropping the wages of the person. So let's say that you have minors, you have anyone really, it doesn't really have to be minors at this point. But if you have a person that is working for you and they're a cashier and all of a sudden they're short today, you cannot deduct money from their paycheck because they're short. That's just gonna happen. If that were to happen, the minor could go right ahead and turn around and demand the money back. You cannot deduct money from their paycheck if it's going to drop them below the minimum wage. So just avoid doing that. If they're overshort, hey, do the paperwork. Eventually you might get rid of them, but do not deduct them from their paycheck because that is only going to end up backfiring for you. So stay away from that. Also, do not, if something breaks, it breaks. It's expensive, it's part of the business. You cannot start nickeling and diming all your employees if something does break. That's how business works. So just as a reminder, don't start charging employees for things that they break. I mean, if they do it on purpose or something else, you might have to take them to court. But do not charge them little things, do not deduct them things from their paycheck just because you want to recuperate the money that you may have lost there. So proper training avoids that problem. So just don't make deductions unnecessary at this point. Also, if an employee works overtime, you have to pay time and a half. If they work more than 40 hours, you know that they have to pay. So just make sure that you give them the money that they deserve. The last thing is that you want is a lawsuit because you didn't pay what they were supposed to. You don't want that. It's very simple. If they work more than 40 hours, just give them time and a half. If you don't want to give them time and a half, don't make them work 40 hours or more. That's a very simple way of doing it. So just make sure, just do the reminders. Again, things that happen all the time. If they work more than 40 hours, pay overtime. If you send them to training to another location, or if you're training them there at the store, sure, they might not be working at the moment. They might not be helping customers at that time, but they're spending their time at your location to learn something for you. So if you're training them, pay them for it. Anytime that they spend inside your location or on another location on your behalf, because they're learning something new, they need to learn the material. So you need to pay for it. So as a summary again, if they work more than 40 hours, pay time and a half. If you are training them, pay them for it. No illegal deductions can be made that will drop their minimum wage salary below the minimum. Remember, no open flames for minors. You don't want to be one of those statistics of the 32 people that die. Even though the number might be small, it only takes one for you to go to business. So just be careful and stay in compliance. Just as another reminder, if you have noticed, I have really gone over most of the jobs that are non-farm related. I kind of passed by the farm related, agricultural, as it's called, jobs, but I really didn't talk about much of them. Now, the thing with agricultural jobs is that they are completely different. There's really nothing they are totally different things. So on agricultural jobs, farm jobs as it may be related to in some locations, the rules are different. The hours, the ages, everything is different. For example, a 16-year-old in a farm could pretty much do anything. They have no restrictions in hours, no restrictions in equipment. Some equipment, sure, yes, but pretty much the only thing that is similar to it is that it's on the hazardous part. That any employment that maybe happen in a farm cannot be of hazardous nature until they're 18. But they could use equipment. They could be driving machinery at the age of 16, and they could pretty much work the whole day if you want them to, that there's really no restriction. Now that's on farm jobs. Someone that is 10 years old could be doing farm work. Granted, they're not going to be driving a tractor, but they could pretty much do anything else. They have some limitations in hours, depending if they're going to school. You have to have a paper signed from their parents, the guardians, saying that you're authorizing them to work there. If the farm happens to be a family-owned one, from your own family, forget about the papers. They are your parents. They could have you do whatever they want. There are really not a lot of limitations there, but you just have to be careful, because at the end of the day, you're in a farm. A lot of accidents could happen, especially if you have a 16-year-old driving a tractor when there's a 10-year-old picking up a harvest in the middle of the road. Accidents could happen, so you have to be extra careful when that kind of stuff happens. I mean, so 16 and up, they could pretty much do whatever. There is no restriction in hours. They could, when you are 14, there have some restrictions in hours, but you could technically work outside school time with no restrictions. You could do harvest at 10 years old. Again, you're doing a harvest at 10 years old, and even at a younger age, if it's a family-owned farm. So I just want to make sure that I know that I didn't go over a lot of information over the farms. If you have any questions, please go ahead and you could ask me, and I will answer as many questions as I can. We will find the answers if I don't have it right away, but I will be more than glad to help you with it. Now, one of the things that I really want to make sure is everything that I have said so far is primarily for non-agricultural jobs. So anything that is outside a farm. Farm jobs are completely different. Farmers could have another presentation just like this one about farm jobs and what they can and cannot do. The minimum wage is different. The hours are different. The education is different. The training is different. Everything is different on farms. So just make sure that whenever you are hiring, just make sure that you understand that if you're going to go to a farm, or you're going to be a manager or some sort of farm, you need to do your homework under all the new regulations and all the steps that are needed for farms, because agricultural jobs, again, they're different. So I don't want them to get confused. Just remember that the agriculture jobs is a completely different animal. That needs a whole different training, really, to be able to understand everything that goes on there. Safety, again, in both places is the number one. You do not want to have any accidents. An accident on a fryer could be, sure, you got burned, you go to the emergency room. In an accident on the farm, it could be a tractor trying to run you over. That's to make it an exaggeration, but it could happen. So farm jobs could create a lot of problems. So just make sure, at the end of the day, pretty much what we're looking for is that the kids are safe, the minors are safe, you have no problems with their parents, that you're following the law, and that you're making money. At the end of the day, your business, you want to make money. And as managers, as owners of the businesses, that's what you do. So the best way to make money is not to lose money by having violations. So just make sure that you follow the rules and you should be okay. So if you have any questions, please go right ahead. For the last 5 years, the Wage and Hour Division has reported a decreasing number of child labor violations. These violations come to light when a random inspection is made or someone reports the violation. For the year 2013, there were a total of 704 cases found with an average of 2 minors per case. It is our duty that we keep our establishment in compliance and that we take what we have learned today and put it into practice. Remember that one incident can be enough to cost you thousands of dollars in fines, not to mention the possibility of legal action against you from the minors' advocates. Congratulations, we have made it to our last test your knowledge. So I want to make sure that you really have gotten this section accurately. The compliance section is just as important as the law. If you don't follow the law, you're going to be out of compliance, and if you're out of compliance, you're not following the law. So they go hand in hand. So question number one, a 15-year-old student working at 10 p.m. on a Friday, do you think that's going to be considered a violation? What about a 17-year-old student working at 9 p.m. on a Sunday with a fryer? Is that going to be a violation? I don't know. What about a 13-year-old student working at 6 p.m. on a Tuesday? Do you think that's going to be a violation? Well, according to the state of Florida and all the rules that we have just gone through, the 3 of them are violations. If you're asking yourself, why are they violations? Why a 15-year-old cannot work at 10 p.m. on a Friday? Very simple. 14 and 15-year-olds can only work until 9 p.m. on Fridays. 16 and 17-year-olds cannot work on fryers, as these are dangerous equipment. Really, anyone under the age of 18 cannot work on fryers. And minors under the age of 14 cannot work. Period. They cannot work. Unless this is on with the guardian and that's going to be on a farm or doing giving newspapers. So by at 6 p.m. they're not going to be doing that. So remember, when we talked about farms are completely different. They could do whatever they want in farms, and there's no age limit. So just remember that. So anyone under the age of 14 cannot technically be working. So 14 is the cutoff time. So now we have come to the end of the training. I will provide you a summary of what we have gone over so far. We have covered a lot of material, so I'm not going to go step by step of everything that we have done, but I'm going to tell you what we have done. So in part 1, we got to know the individuals that made the laws possible. We got to the history. We got the names, we got the dates. In part 2, we went through the requirements of the FLSA and the state of Florida. Pretty much, those are our backbones. We have to follow FLSA and the state of Florida. Remember, some places, some things go by the federal standard. Some of them go by the state of Florida. So the stricter version is the one that the state of Florida takes. And finally, in part 3, pretty much the implementation of the consequences. We learn how important it is to be consistent with the laws and the implications and consequences when they're not followed. So we learn what happens when you don't follow the law and what happens when you follow the law. When you follow the law, no one looks at you. When you break the law, everyone is looking at you and you get in trouble. So it only takes one time for you to get in trouble. So just follow the law and you will make me happy as your trainer. So if you have any questions, let me know. I want to ask you one more time, any questions, any concerns? Go right ahead and ask. Otherwise, I'm very thankful that you were able to all make it today. You were on time. That helps. It's always good. And again, thank you for your participation. I know that you're all going to be in good shape and compliant. So if you have any questions, you got my number, you got my papers, the things that I gave you, contact me and I will be more than to answer any questions for you. Better safe than sorry. So thank you again. Have a safe drive back home. And if you have any questions, I'm here to help you.